Welcome, everyone. My name is Marc Movsesian. I'm the director of the Center for Law and Religion at St. John's. I'm here with my colleague, Marc DeGirolami, the associate director. And this is the first in a new series that we call Legal Spirits. Now, we've done some podcasts in the past. This is not entirely new, but this is going to be a series which we'd like to do at least a couple times a month to address important cases, important legal issues in the news, important matters of legal debate relating to church and state and law and religion generally. This will be the first one. And for our first one, we're going to talk about a case decided earlier this month by the UK Supreme Court called Asher's Bakery. Marc?
Yeah, we'll then use the occasion to compare this case and the holding in the case to a prominent case from last term from the United States Supreme Court, the Masterpiece Cakeshop versus Colorado Civil Rights Commission case involving similar kinds of issues, although not exactly identical.
Right, that's what makes this case so interesting. You see, both in the UK and in the US, courts are addressing the question generally about how to balance anti-discrimination laws with respect to public accommodations. These are laws that say that public accommodations cannot discriminate on a variety of grounds, including sexual orientation. How to balance those laws with the greater societal interest in freedom of religion and freedom of expression.
Yeah, and I think, Marc, you're right. These cases are relatively new. They've been occurring in the United States at the state level for maybe 5 or 6 years at least, but probably they're going to be with us, I would expect, for a number of years going forward. Certainly in the United States they will, since the holding in Masterpiece was a little bit narrower and different than the holding that we've got in the UK.
Yeah, and Masterpiece Cakeshop really didn't settle a lot of the issues, and so certainly it's going to come back.
Yep.
Okay, so let's talk about Asher's. Asher's is the case from the UK. Asher's began about 4 years ago when Garth Lee, who is a gay man, placed an order with Asher's Baking Company for a cake for a party he was going to. He was going to a party at an LGBT community organization called Queerspace, and he asked Asher's Bakery for a custom cake. And the cake was going to include a picture of the Sesame Street characters Bert and Ernie, also the logo of the LGBT community organization called Queerspace, as I said, and then a slogan. And the slogan was, "Support Gay Marriage." It turns out that Asher's owners, Amy and Daniel MacArthur, are conservative Christians, and they had a problem as a matter of religious conscience with gay marriage, and so they told Mr. Lee that they were not going to be able to fill his order. Shortly thereafter, he found another bakery and then went to Northern Ireland. This took place in Belfast, I should have said. So Garth Lee then went to the Northern Ireland Equality Commission and brought a lawsuit against Asher's and against the MacArthurs for discriminating against him in violation of British law. And he argued that Asher's, which is a business open to the public, had violated his civil rights under British law by refusing him service because of his sexual orientation and also, interestingly, because of his political opinions, that is, his support for gay marriage. And Marc, this is interesting because generally speaking, we don't have that concept in American anti-discrimination law, the idea that a public accommodation cannot discriminate on the basis of the customer's politics.
Yeah, and when we get to this part of the claim, we can talk about it. It seemed to me, at least when I read it, I was wondering how could one possibly have a non-discrimination provision with respect to politics that would not run afoul of the freedom of speech under the Constitution. I mean, there's such a close connection. First of all, freedom of speech is widely considered to be at core about political issues, that one should have the freedom to say whatever one wants, particularly when it comes to politics. So the coexistence of a non-discrimination provision with respect to politics and the free speech clause seems to be especially problematic.
Yeah, it is problematic. You know, most American jurisdictions that have public accommodations laws do not cover political affiliation. So if a public accommodation declines to fill an order or declines to serve someone on the basis of that person's politics, in most jurisdictions that's legal. It's not in some. Some jurisdictions, for example, D.C. has a public accommodations law that forbids discrimination on the basis of political affiliation. This might come up more and more now. You know, our politics is becoming increasingly bitter. You know, there have been situations in which restaurants, for example, have refused to seat members of the Trump administration on the basis of politics. So this could come up. So far, however, it's not really a live issue here, as it is apparently in the UK.
And I guess, Marc, that maybe the distinction is one that has crept into some of these other kinds of categories of discrimination as well, the distinction between status and conduct or status and belief or something like that. And certainly that's become powerful in the sexual orientation discrimination context, and possibly, although perhaps to a lesser extent, in the religious discrimination context. But it's difficult to know what it would mean to say what exactly is the difference between discriminating against somebody on the basis that they are a Republican as opposed to on the basis that they believe in the Republican platform.
Right. Well, very interesting. Okay, so let's look at the UK Supreme Court opinion here. The UK Supreme Court said, actually, that the bakery should win, which is also, by the way, sort of unusual.
Unanimously, right?
Unanimously said so, which is unusual because in most of the wedding vendor cases, at least in the States, the wedding vendors lose. But let's look at what they said in this case. First, let's talk about Mr. Lee's claim that Asher's Bakery had discriminated against him on the basis of sexual orientation because they wouldn't fill this order for the cake. What the UK Supreme Court said here in, as you say, unanimous opinion written by Lady Hale, who's the president of the court, the UK court said that this was not a matter of discriminating on the basis of sexual orientation. Rather, this was the MacArthurs deciding that they did not want to endorse a specific message. The MacArthur's message, Lady Hale said, the MacArthur's objections, Lady Hale said, were to the message, not to the man. They had sold cakes to Mr. Lee in the past and would have done so again, just not a cake that said support gay marriage.
So, Mark, it was very important in this case to the court's decision that there was a specific message that was being expressed on the cake.
That was the whole thing. It was the message, not the man, that the bakers were objecting
And here the message was an explicit worded message on the cake.
Support gay marriage.
Yeah.
In fact, the court said the MacArthurs, the evidence was, the MacArthurs would have refused to create a cake with a slogan in favor of gay marriage for a straight customer, as well as for a gay customer. And the mere fact that a customer requests a cake celebrating gay marriage didn't imply that the customer himself was gay, or that the refusal to create such a cake would constitute discrimination on the basis of sexual orientation.
Now here, Mark, I wonder, just a question about the distinction between status and conduct that wasn't persuasive to the court. You know, there have been cases in the United States, CLS versus Martinez, and so on, that says that it's not possible to separate the status of a certain sexual orientation from any particular conduct or belief or view, and that didn't seem to come through from what I saw.
Not a major part of the decision. No, they basically said that, look, the MacArthurs would have said no matter who it was who asked for a cake if the cake said support gay marriage.
Yeah.
Okay.
Interesting question. Here's a thought. Suppose you didn't have the words, but you just had Bert and Ernie, for example, or so you just had maybe a rainbow flag or something like that, where the message would have been more diffuse or not less explicit, whether the court would have come out the same way.
Yeah, it's a question. I mean, I think it's pretty plain that Lady Hale's opinion says that anytime someone objects on the basis of the message, however that message is portrayed, that's not discrimination on the basis of a forbidden ground in the UK. Now, there was also, as we said a second ago, Mr. Lee also had a political discrimination claim under British law. He claimed that the Asher's Bakery had denied him service because of his political opinions. That is, he supported gay marriage. And here Lady Hale said the claim was a little stronger under British law, but also failed. The MacArthurs, she wrote, had not refused service to Mr. Lee because he favored gay marriage as a political matter. Rather, they had declined to express a political opinion with which they themselves disagreed. And they had a right to decline. The European Convention on Human Rights, which Britain had signed, forbids laws compelling people to express beliefs they don't hold, at least where the laws are not, quote-unquote, necessary to promote a quote-unquote legitimate state goal. And here, the government would be compelling the MacArthurs to express an opinion in favor of same-sex marriage, which they opposed. Now, there are a couple of issues I'd like to address here, Mark. One of them is the question whether when a baker makes a cake for a customer, the baker is really expressing any opinion of his own. This argument came up in Masterpiece Cakeshop as well. It was not in the opinion, but actually was in some of the briefing.
Yeah, and I know, Mark, that it's a view that you actually have some sympathy with. That,
I do.
The view that a baker, there is no necessary attribution to the baker with respect to the message that the baker is including on a particular cake. The message is clearly ought to be understood by most people as the message that the customer wants, not that the baker wants. And I think that's My own view is that that's probably true in the vast majority of cakes that bakers make, that if it's a happy birthday Timmy or something like that that's requested by a customer, I mean, I'm sure the baker feels very kindly toward Timmy, but I don't think that he necessarily intends to wish Timmy happy birthday just by expressing that message. But the court seems to draw a distinction here in the Asher's case as well as in Masterpiece between personal messages like that and then other kinds of messages in association with the trademarks or logos of or names of the bakers as being messages that can be somehow attributed to or assigned to the baker.
Yeah, and Lady Hale said in a case like this, the baker had every right to object. She said, for example, what if someone saw Mr. Lee carrying the box with Asher's Baker's logo on it and open up the box and there's this cake that says support gay marriage? The public could reasonably think that Asher's Bakery supported gay marriage. That's what Lady Hale said. So
and I guess this comes down to a reasonable attribution, right? Is what a reasonable person would think, something like that, and anytime you get into those kinds of questions, of course, those are going to be inevitably murky and depend on some sort of objective external standard and so on.
I would think, but Lady Hale seemed to think, look, it just doesn't matter because anyway, the point is that the state cannot force someone like the MacArthurs who run Asher's Bakery. The state cannot force someone to create a product that actively promotes a cause with which that person disagrees. Now, there's another issue here, as I said, that under the European Convention of Human Rights, the government can't force someone to express an opinion that he doesn't share, at least unless the state doesn't have some legitimate goal, and forcing the person is necessary to advance that legitimate goal. And here, Lady Hale said, well, it's true that there's an interest in ending discrimination on the basis of sexual orientation. That's surely legitimate. She said denying someone equal service because he is gay or because she is lesbian is deeply humiliating and an affront to human dignity. But, she said, the MacArthur's refusal to make the cake in this case didn't implicate that interest in human dignity because refusing to design a cake with a pro-gay marriage didn't constitute discrimination on the basis of sexual orientation. And she said, it's an interesting quote, she said, it does the project of equal treatment no favors to extend it beyond its proper scope.
Now, I just have a question about this. So the court gets into all of this discussion about the convention because it says, getting back to our initial discussion about the distinction between status and conduct, because it says when it comes to the political opinion, it's much harder to dissociate political opinion from political status. The issue of political status and political opinion in the language of the court could be argued to be indissociable, which I thought was interesting and persuasive, and I suppose it's just for that reason that they had to start talking about legitimate interests, which in our jargon are kind of like compelling interests.
Yeah, right. I think what Lady Hale says there is, well, I don't think this is a winning argument, but at least it's worth treating it seriously, and that's why we have to go through the European Convention analysis.
Right, which is interesting comparatively because I think we in the United States would be much more likely to say that sexual orientation and conduct or belief are indissociable, are much more likely to be indissociable perhaps than political opinion. Or this court here goes somewhat in the opposite direction.
Yeah, well, we just don't have that. But let's actually move to what implications this case has in the United States. What do you think, Marc? What implications does this have after our own case, Masterpiece Cakeshop?
Well, of course, strictly speaking, none, because it has no binding effect. And most justices, I think, on the court right now, it was interesting to see that the UK court cited Masterpiece Cakeshop. Distinguished it, but cited it, relied on it. It did characterize Masterpiece Cakeshop as being about the distinction between discrimination on the basis of the message as opposed to the individual. I'm not so sure it characterized it correctly.
I agree.
So there's a question about whether Masterpiece Cakeshop is like this case at all. It seems to me it's quite different from this case, and the UK court's statement that what Masterpiece Cakeshop was about was really about the difference between discrimination on the basis of viewpoint or on message and discrimination on the basis of status, I don't think that that's an accurate characterization of Masterpiece.
Yeah. Now, one difference between the two cases does jump right out, and that is in Masterpiece Cakeshop, the gay couple, Craig and Mullins, wanted a cake for their own wedding. And this case, the Asher's Bakery case, it was not for Mr. Lee's wedding. He just wanted it to go to a party. And anybody can bring a cake to a party that says support gay marriage. You don't have to be gay. But very few people will actually want a cake for a gay wedding unless they are the couple getting married.
Well, that's true. That is a distinction. How it will cut in the United States, it did seem to me that at least Justice Kagan's concurrence, the fact that this was a wedding cake in celebration of the customer's gay marriage was important for her point that there is no real distinction between discrimination on the basis of message and discrimination on the basis of status. In other words, that this really made it closer to discrimination on the basis of status.
Because it's for the person's own wedding.
Because it's for the person's own wedding.
Whereas this case really wasn't.
This
was
is really about expressing a view as opposed to
Correct.
expressing something about oneself.
Right. So a case in which a gay couple comes in and says, we'd like a cake for our wedding, that seems a stronger case for a discrimination claim than a case like this where someone just wants a cake for a party.
I think that's true. Although it seems to me, again, depending on which of the concurrences in Masterpiece is ultimately successful, either Justice Gorsuch or Justice Kagan, Justice Gorsuch's concurrence would seem to me to go for the baker in both sorts of situations.
Right.
Right? You would agree?
I think that's right.
Yeah. So, as we said, Masterpiece is a much, much narrower case. It ended up, as we all know, being a free exercise case. It was not about compelled speech in the way that the UK case was.
Based on very specific facts, you're not going to have a lot of cases in which commissioners actually make comments disparaging religion.
Based on very specific facts, it will depend upon whether the evidence of disparate treatment of different bakers in other sorts of cases, whether the court fastens on that, or whether it decides, as Justice Thomas decided, to take on the compelled expression cases. I noticed that the UK court actually cited the Barnett case. So it seems like the UK court is more amenable to taking into account American precedent than perhaps the American court.
That's true, and it's ironic because, of course, the one justice who is, in my mind, one of the two justices most associated with the idea that you can look to foreign sources as persuasive authority was Justice Kennedy.
That's true.
And he's now gone.
That was in Roper versus Simmons, right? He did the same thing in the death penalty case, right? For juveniles.
I mean, I guess to wrap up, I think what I'd say about this case is, to the extent it will have any value in America, it is this idea that one must distinguish between objections to the message and objections to the person. That's a very strong theme in the Asher's case from the UK Supreme Court, and if American courts were to adopt that, again, it would play out in different ways in different contexts, as we've talked about. That really does seem an important principle that might change the results in some cases.
I think you're right about that, Mark. I'd just point out one other factual difference, and that is, in this case, you really have, that's to say in the UK case, you really have some strong messaging on the cake itself, whether it's the images or the very wording of the cake. In Masterpiece, you did not have that. You just had a wedding cake with no messaging or no specific expression in favor or against any particular position. And so it makes it a more difficult case for that reason also, to make it a case about compelled expression. Not impossible, but more difficult.
Okay, great, Mark. Well, thanks very much. Let's wrap it up there. Thanks very much for listening. As I say, this is the first in a series of podcasts called Legal Spirits. Join us again next time.